Thank you for joining us here at Living Equity. Today, I want you to trust me as we go over some of the things regarding what is a trust, how does a trust work, different kinds of trust. But without me talking too much, because I can, let me get straight into it. So, as the presentation shows above the title, trust me. So, what is a trust? This is going to go over the elements, principles, duties, the parties, title relating to the property, and equity, which we like to call performance for short. Now, understand there are 80 different kinds of trusts. Okay, depending on what you need. There's a business trust, there's an insurance trust, there's a charitable trust, a spendthrift trust. There's family trust. All right. There's land trust. There's gun trust. There's many kinds of trusts. So let's just focus on what we need. And what I would say for you to just kind of out of this presentation, think about what kind of trust are you in need of? And for us to give you more of a background, what that would look like, if you want to, clear that up and kind of just foggy still, schedule a consultation with us, and we will help you with that. So the third one is what trust fits you and your goals or your family mission, as I just stated, right? What goals fits you, your family mission, what are you trying to do with it? Will tell us the type of trust that you need. Because not a one trust is going to fit all. It doesn't work like that. That's why people have multiple, businesses and things of that nature for multiple reasons. It has its own functions. It has its own mission, right? So why do you need this kind of trust? For what reason? Is a revocable trust versus a irrevocable trust? And when does it benefit you to have one of the two? Definitely going to break that down. What is expressed and what is implied? Well, sounds simple as we read it. Expressed is what we, express ourselves, say, or orally say, or written down, or can be seen in our actions. That is also a form of expression, but it's typically something written, something that we can see, right? Uh, Typically, things that are not seen will be called implied because it is based on your action. Though you're expressing yourself through your actions, it's truly implied because of your actions because it's not written down, right? The mighty of that power of the pen, right? To have that written down, right, on paper. And again, how does it affect you when it's implied or expressed? How does that actually work in the real world where we don't even know a trust is actually going on and the trust this transaction is actually going on right in front of us, but because we don't know, we don't see it, we don't think it exists, we care less, and it's truly going on, even in an implied way as well as express way sometimes. What is a constructive trust and resulting trust? How does that benefit or affect you? Uh, Common law trust explained, or even common law itself, we're going to go over. What is common law? Some say judge-made law, right? Case precedent in support of that. So we're talking about U.S. Appeal Court case laws and Supreme Court case law. We may be talking about different levels of you know, some state Supreme Court, but primarily 99% of the time, I'm giving you federal appellate court and Supreme Court cases and decisions. And we're all going to go over as well. What does the IRS say? What are their view on trust? Because most of us are worried about the IRS, right? It's like the boogeyman, right? He comes out, and sometimes we don't even see him coming. And he's even a silent partner of many of your contracts that you don't even know about, your qualified accounts, your retirement accounts, all those things. You don't hear from this guy until it's time to pull out, right? That's when it's time to pay up, right? Sounds familiar. Well, let's keep going. All right, sorry. What is a trust? Well, in general, the definition of a trust is a right of property, real or personal. So it's not just the property itself, it's the right to the property. So you can even, we can't see the right. We have the right to breathe. You may see me breathing by me being alive, but can you really see me breathing? Right? Unless you really pay attention to me. Maybe, look at my chest, heartbeat, whatever. But it's a right. You can assign a right. You may have a right uh, to benefit from having a home or the use of any form of property. And based on how that property is given to you, um, you may be able to assign that right to someone else, whether it be real or personal. So it says, again, a trust is a right of property, real or personal, held by one party for the benefit of another. Okay. From this broad definition, numerous types of trusts are derived because a trust can be created for any purpose which is not illegal or against public policy. Okay. When we say against public policy, as long as it's not injurious to the public at large, so you have your right to be private as long as your privacy is not inflicting on others. It's not damaging others. Okay. So as long as it's not doing that, it's not against public policy. But again, it's not just the property itself, but it's a what? A right to the property. Along with the property at times, they may be having possession of it, right to use it, so on and so forth. Well, why do we need a trust? What are some reasons we need one? Well, I trust me because I understand that there's a lot of people that I've seen and heard and have done business with. Um, the biggest thing is probate costs, attorney fees, court fees. I mean, it's not just having to pay an attorney. If you have a large estate, you have to get things appraised sometime, and that cost. You may have a large estate. I think currently it's 13 million. And there's I don't remember exactly the estate tax. I'm going to give or take anywhere between 25 and 35% for an estate tax. So you do the math on that 13 million or 11 million, whatever that threshold is for you to be taxed, actually. And that's going to come down. We are due, I think it's 2026, 2027. A lot of taxes changes are going to come. A lot. I think it's one of the bills that's expiring from 2017 when 45 Trump was in office. Number two, avoiding creating generational family disputes. Yeah, well, that's a big one. People fighting over who gets what, right? Ain't nothing like that because they're getting along now. But if you leave any money behind, things get muggy, get sticky when it comes down to money. People true ways come out. And it prevents that confusion on how the assets are to be disposed of. I mean, besides being mad at each other for fighting over who gets what, let them be mad at you while you're in the grave. Lessens that dispute. Let's see. Number three, it avoids personal liability, so we can help you reduce taxes and avoid a tax, not evade. The key word is avoid and reduce taxes. Now, people might say, well, wait, isn't trust more in taxes than it is with your personal income or LLC or give or take? I would say to that is we structure in a way to where we use the trust as within our structure to help transfer that tax liability in a very unique way where we can help reduce that tax liability completely. Well, yeah, that's what I'll say to that. And, we do have trusts out there that can avoid a business tax responsibility when you're doing business, right? And typically that's a business trust. As I mentioned from the slide before, you have ways you can do it with an insurance trust by setting that up a certain way where you can avoid a tax on a cash value insurance policy. Maybe you went over the MEC limit, and maybe that money that's over that modified endowment contract limit, so set by the IRS, which is called a MEC. If you go over that, those funds will be treated like a qualifying account. So there's a tax responsibility on it. And we want to know ways we can prevent and avoid that. Well, we help do that. Liens and garnishment on your personal income or on your personal property. Well, if it's not in our name, we don't own it, you can't take it, right? But it's not mine to take. You can't take it. Number 4, building generational family wealth. As I stated before, we will use things like insurance, trust, to show individuals how to make that money last forever. Also, charitable trust, how we help you get, a present tax deduction for using not-for-profit organizations or a charitable form of trust, in the form of maybe a trust in the form of foundation, a foundation in the form of trust. So it's many ways we can do that. And again, I will say number 5 really truly should be like, not number 1, number 2 or 3, but encourage long-term financial accountability, education and training, creating long-term habits to help to protect, it's supposed to be to protect, excuse me, and grow the family wealth. I think that's as far as important as the property itself or the asset of the wealth itself. Because, if you got bad habits, your family is going to end up back in a bad situation. The habits are not good along with the money itself or the asset itself. So you got to have great habits if you're going to be, passing down wealth for generations, because typically it doesn't last any longer than 50 years. A lot of them, go poof before that. Many generations spend most of their inheritances in 18 to 24 months. Most of it's gone by that time. So you want to put things in place to where it's educating them. It's setting, it's like forced education, to be honest with you. If you want this access to this money, to this wealth, to this asset, you got to do X, Y, Z. You have to be involved. You have to do this and do that. So it's enforcing that for sure. Who may create a trust? Well, in order to create a trust, the settlor must own or have a power over the property. As I stated before, they must have a right to it, which is to become the trust property, or must have the power to create such property. Legal disabilities of a settlor may render his attempt at trust creation void or voidable. If a settlor is illegally induced to create a trust, his act may be void or voidable. So legal disabilities are like incompetency. Maybe they're minor. That is a form of a legal disability. Maybe they were in the hospital bed during the time. Maybe incapacitated in jail. Right? These are disabilities that could be challenged, or that could void the entire trust completely. Methods of trust creation: a declaration by a property owner that he holds the property in trust for another, or procuring such a declaration by another. A transfer by the owner of property or the holder of a power of appointment over the property. Now, now let me break that down. Who's the holder of a power of appointment over the property? Your trustee. The trustee is considered, as soon as the trustor gives his rights away, the settlor, trustor, or grantor, the ORs positions. There's 3: trustor, grantor, settlor. And when these positions give up absolute rights, 5% or less total control of the trust, it becomes a revocable trust at that point, in which the trustee has all the power and discretion. So they're the holders of the power of appointment over the property, which is to be managed for the benefit of another person, which is called the beneficiary. So that's the holder of power of appointment, which is, i.e., the trustee, or of that property by deed or will to another to hold in trust. Number C is really 3 in total, but I have my ABC. Making or procuring to be made a contract to pay money or deliver property. I'm gonna pause there. Now, I hope you were realizing the 3 things that will help create a trust here: declaration, transfer, and contract. Contract is the biggie. That's the beauty of them all, because we understand contracts are protected by the Constitution. You don't mention transfers. You don't hear declaration. Well, you do hear declaration, in all honesty, in the Declaration of Independence, and some form of transfer in the Declaration of Independence when they're talking about unalienable rights, meaning your rights cannot be voluntarily or involuntarily conveyed. But in what we're doing now and how we're using this where it becomes effective is in the form of contract. And truly is. Though a trust is not a contract, it's not to be confused. But there's a contract that exists between the parties called the trustee and the grantor, settlor, trustor. Okay. Let's read that again. Making or procuring to be made a contract to pay money or deliver property to another, which the payee or transferee is to hold in trust for the third person. So they call it a payee or transferee in this situation because, as it shows here, a contract was made to pay money or deliver property to somebody, right? So that person who's paying the money and delivering the money is called the payee transferee, but essentially it's creating a trust because they're under a duty under a contract to do something for someone or on behalf of someone on behalf of someone else for someone. I hope that makes sense to everyone. We have express trust. One of these various types is an express trust created or declared in express terms, usually in writing as distinguished from one inferred, by law. Another necessary qualification that is placed on the express trust is that it must be active. So you got a difference between an active and a passive kind of trust. Passive is just something that does nothing. Sounds what it sounds like. It does nothing but hold. It holds property. It's passive. Active, well, it is active, is where the trustee has the authority to manage the property of the estate and to pay the net income to the legatees or beneficiaries. Well, that's an active. It manages, it pays out the property of the estate to those entitled. Such express trusts were quite prevalent in England from the 15th century to date for the purpose of estate management and preservation. They were so widely used that they became part of the common law, and courts of equity were set up to handle them. Well, what are some courts of equity, you ask? Family court is one. Definitely. It's one of them. Foreclosures is not a court, but an action in equity. They're suing because you failed to perform, right? It's definitely one. Express trust continued. Rather, it is a trust created by private contract. Private contract. Private contract for the holding of a divisible property interest wherein the trustee is empowered by the settlor to do for a beneficiary of his trustees, choosing whatever he may do for himself as an individual, sui juris, in his own capacity, right? So again, the trustee in this situation is a private contract between the trustor and the trustee, to where the trustee has discretion to do for the beneficiary and which he would do for himself, which should be in the benefit, because you wouldn't think that one would do things that will put him in a detriment, right? But he is to follow that trust instrument called an indenture, which is the trust instructions and how he is to perform. It may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Doing so requires no benefit, privilege, or franchise from any form of government or other outside party. And therefore, the parties owe no duty to any form of government or other outside party, to the extent that no common law, criminal, or civil wrong is the purpose of the contract. Public versus private. Well, we have many trusts out there that is in the private and public, primarily the public domain, or being sold in the public domain in our public trusts. And there's public and private property. That's very simple. I don't even think I need to expound more public and private property is. But let's break this down, right? So this term real estate is a great example. So the term real estate really means that the property is recognized and regulated in government statutes that can and do only regulate public property. So owned or at least controlled by public/government. Hence, it becomes real in the eyes of the government, and consequently within the jurisdiction of government. It is otherwise repugnant to the Constitution, as held by the U.S. Supreme Court, to regulate exclusive private property that is absolutely owned. I mean, I couldn't agree with that anymore at all. That is actually on point. Okay. And it says this act of registering property or title to property. So what happens when we register our property? All right, I'm gonna be going a little left here, but it's the honest truth. Register, right? Regis, Regis, that's king. And let's be honest, etymology words are important. Okay, I care less what it means today. All right, the root of the word is just as important as it is then as it should be now. Okay, things not by a fruit it bears, right? The fruit that it bears, but without its roots, there will be no fruit. So registering is actually putting yourself under the position of a sovereign when you register your property with them. Okay, now there's ways we can avoid or reduce doing such a thing, and then which puts us in a taxable situation. Okay, well, the act of registering property or title to property, it donates an interest in the private property to the public in exchange for the benefit of one or more types of protections. So when you divest your property right to the public entity, you're exchanging that right for a benefit in which they can offer you. Maybe it's protection, police force. Well, honestly, the police doesn't have a duty to protect you, and that's been ruled by the Supreme Court. It's no duty for them to protect you at all. They're there to actually protect the public interest, which is the government's interest, not so much you. It changes the character of ownership of the property from an absolute to a qualified. So you went from an absolute owner to a qualified owner. Well, what is a qualified owner? Well, an absolute owner is somebody who absolutely owns it. It's original absolute owner. Like fee simple, absolute. They're the absolute owners. Qualified is you share that ownership with somebody. Doesn't that sound familiar? Qualified retirement accounts. You are sharing ownership with an entity called the government by Congress, actually, through a private entity called the IRS. It's qualified because we're not taxing you now. We're going to tax you later when you don't know what tax is going to look like, what tax bracket you're going to even fall in at that time. It's a lot of things you don't know. Qualified owner, you're sharing ownership. Qualified retirement account. I mean, as I said, these words and how they're used, they don't fall too far from the tree here because, boom, right there in your face. Well, what is a contract? How do we get a contract? And contracts are protected by the Constitution and can be made with private parties. Well, contract must be made with the competent parties that have legal capacity, mental capacity, meeting of the minds. To have legal capacity, the only way you can have the meeting of the minds, everybody's in the legal capacity. It must be lawful and must have some terms. Doesn't a trust have terms to it? It's not against public policy. That's the answer to the public. Offer and acceptance, a promise to do or not to do something. The person must accept to do or not to do something. Consideration, it must be viable and lawful, measured and lawful. That's how we get our contracts. Same thing you're going to get as a trustor or trustee, in which he or she is not volunteering to do this thing, but they are are doing it through consideration, because without that consideration, you're not going to be able to sue them in court because they did it voluntarily. So there's no consideration passed. You can't enforce suit. And of court of equity, meaning we cannot enforce them to perform. This is why we always give consideration to the trustees. So just in case they don't do their job and we're long gone, the beneficiaries can enforce it. Declaration is the instrument that constitutes the trust. It has been noted in trust law that no technical expression are required to create a valid declaration. So as long as the words used make clear that the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. Moreover, the declaration, by its terms and provisions, serves to establish the entire contractual agreement, including the identities and positions of the parties, trust names, jurisdiction, the situs, which is the location, and all particulars of the administration, of all which the courts of equity will fully support by the principle that equity compels performance. Elements of a trust. You have the trust intent. Can it be seen by his actions or from his expressed words? Again, actions can be implied, though, so it must be in words. Specific trust res, the property to the trust. Properly designated parties, the trustor, the grantor, settler, which is typically the same person, right? Or you could have more than one. Far as two grantors, two trustors. Then you have the trustee, and then you have the beneficiary. Those are your parties: trustee, trustor, beneficiary. Valid purpose must be lawful. Consideration is not required. It is not required like a contract. It is definitely not required. But if you want to enforce performance, you must give it. You must provide consideration. Distinct titles. So you have legal title, you have equitable title. Let's talk about legal title. Well, you have two titles in one piece of property. So one piece of property can have two separate titles. Okay. Now, let me give you an example. Let's go back to the foreclosure. Now, we know foreclosures are not necessarily, mortgages are not really trusts, but they kind of resemble it in a way, right? And it's a great example we can use to show a trust relationship. So with a house, you have payments. So you are under a legal duty, to perform. It's called the legal title. The trustee typically has the duty to perform, but you're like, well, wait, it's my home, it's for my benefit. What do you, take that out of your head right now. Just think about it. Follow me for one moment. So you have the legal title, which is a trustee, the legal duty to discharge or perform, a right to hold for the benefit of the beneficiary, also known as the legal owner. Now, I got a question for you. Are you the legal owner of your home? Yes. Are you in possession of it? Yes. Are you performing? You might pause. But yes, you are. What are you doing that's considered performance? You are making payments to who? A beneficiaries in a trust called a pool of mortgages. Okay. You are paying payments in which beneficiaries inside of a trust are receiving in a pool of mortgage pools, which is mortgages, a pool of a bunch of people's mortgages in security. And they're getting paid. If you don't pay, they what? Take you to court, enforce performance that you pay, or foreclosure that they take the property out of you because you breached. And we can go into, oh, mortgages paid, my God, we can go to all that, and this is not the time for that. I'm just trying to give you an understanding of how kind of trust works and regarding the titles. Okay. Well, the people who are receiving that pool in that pooling, the beneficiaries, if you were to get sued, it'll say the trustees for the beneficiaries of the said trust. If you ever been in foreclosure or dealt with foreclosure, you know what I'm talking about. They're called the equitable beneficiaries, which is the equitable title. They're holding the equitable title. They receive the payment. So the trustee is called the 9/10 holder. He has possession of the property and he has to perform, whether it's payment, whatever he has to do, he has to perform. The equitable title is called the 1/10 holder. He receives the rents, the profits, the proceeds, the shares from the performance of the property that the trust holds passively or actively, or that the trustee holds, passively or actively. A right to enforce performance through the use of courts of equity. So one piece of property has two forms of title: legal title, equitable title. It's called the bifurcation of titles, the splitting of titles. And each title has its duty. So I hope that helps. The natures of trustees' interests. Trustees are said to have a bare legal title, devoid of beneficial ownership, holding property for beneficiaries in accordance with trust. The trust estate is not liable for trustees' personal debts. So trustees get in a bad situation, he's in the pickle, he cannot encumber the beneficiary's equitable interest. And if he does, that's a breach. And honestly, breaches are considered felonies, and you can serve some time in jail and have to pay that back. You got different types of trustees. A settlor may appoint a single or two or more co-trustees. So can the trustees. The trustee can be given the right to appoint other trustees. He may create different types of trustees with different functions, as where he appoints a trust company as custodian trustee to have possession of the trust property, and an individual manning trustee to make investment collections and distributions of that property. So you can have multiple trustees doing multiple things for one piece of property. I'm going to pause there with pure trust. And yeah, so hopefully that helps you guys of some basics of what trust is and how it works, why you want it, why you may not want it, the different kinds of trust that may exist, certain advantages that you can use with it, some of the education and training that can be instilled in these trusts to enforce behavior patterns that are just as important as the assets, avoiding those, being immune from those lawsuits and creditor detachments, liens, and garnishment. I mean, we can go and keep going, but hopefully this video here helps you and get clear some of that fog for you, and you got a clear understanding what trust can do for you and what it means. And possibly, if you want to learn more, you can sign up and take our mentorship program. We also have our trust products you can purchase. That is available on our website at liveingequity.org. And if you'd like to schedule maybe a 15-minute filler before you purchase any products, feel free to do so. It's 15-minute free call, 15-minute call, in which we highly recommend you do that, so we can kind of know where you're at and how we can help you, and so we can ensure that you get the right product that fits your financial needs as your financial advocate. Also, if you're interested in building that wealth using trust with insurance products, cash value insurance products, we do offer that as well to instill in our wealth protection and wealth legacy strategies, and as well as foundations, charitable trust, unincorporated associations, not-for-profits, uh, and more. So, again, we do thank you for tuning in with us, and hopefully we see you on the inside. May you take care.